Okay, welcome to this conversation. Hello, everybody. And I'm really excited to have Michael Goodyear with me today. Michael, welcome. I think we're going to have a fun conversation about AI and law.
It's always fun talking about AI with you, Joyce, so I'm
Yeah,
sure it will be.
yeah. So you're associate professor at New York Law School, and you're also a legal scholar with a lot of focus around copyright law, trademark, intellectual property, and AI, which is a really hot topic. Um, Before we go into sort of your focus areas from legal research and academia work, you worked in big law and you moved into academia and legal research. How did you make that decision?
Yeah, so I practiced for 3 years at Weil Gotshal in New York City. Was largely representing large tech companies in various things related to intellectual property, including some of the early workings on generative AI tools before they actually came out. Um, and kind of from that, in legal practice, you get to get exposed, especially at these large firms, to really the groundbreaking and kind of most pressing issues of the day. The problem is you don't get to kind of dive into them to the degree that you might want to do. And coming from a background at the University of Chicago, where I like diving into these issues and thinking more about kind of how things should be rather than just kind of what the best argument would be that you can make out for a client, it was really exciting to make the transition to teaching. And I was a fellow at NYU for the last 2 years and working on very similar topics, including copyright and AI, as well as right of publicity, trademark law, and other topics. But certainly, as you said, AI has kind of taken up the attention of copyright scholars and the copyright bar in the last 2 to 3 years, and seems to be probably doing that for the next few as well.
You are a professor and you're a legal scholar. You're also a fellow at various organizations that um, are doing research in this area. Tell us a little bit more about these fellowships and organizations that you're affiliated with.
Yeah, so I'm just wrapping up my fellowship with NYU, where I was both at the law school teaching legal writing, but also a fellow at the Engelberg Center that does a variety of work on issues related to creativity, innovation. Certainly, AI has come in as it does with all these organizations. And so the Engelberg Center puts on a variety of events kind of throughout the year and brings in various speakers and the like. And it's been great to be able to speak with really some of the leading thinkers of the day on issues around intellectual property, AI, how AI should change things, if at all. Um, some of the other affiliations, so now with IPPI, which is the Intellectual Property Institute over Akron, or it's based at Akron. They also have an office in DC, and they have a variety of affiliated scholars and do work on kind of what the underpinnings are for intellectual property protections, how do we strengthen those protections, and kind of how does that work in relation to new technologies or cultural change, which fits very well with my research. And then thankfully, as an academic, I kind of have the opportunity to speak at a variety of different locations, both with legal practitioners, including conferences here in New York City, and then also academic conferences. So probably the most exciting one in the last few months was that I got to speak in Hong Kong at a conference there about machine lawyering, and both a joy to be in Hong Kong for my first time. Hope I get to go back and also be able to speak not just with American legal scholars, but also folks from Asia, from Europe, Australia, and see how other jurisdictions are starting to think about very similar problems. Certainly, this is not just a US problem, even though we
Yeah.
might be kind of leading the market in the technology, but thinking about what other legal systems tools might be.
Great. So now tell us more about your legal research and the specific focus areas that take most of your time right now.
Yeah, so kind of broadly, I focus on copyright, trademark law, right of publicity, and related areas of law. And some of the projects that I'm working on right now, I'm wrapping up a few on AI. As I mentioned, it's taken up a lot of the headspace of legal scholars and practitioners in the last few years. So one piece is relating to how we should think about liability for generative AI outputs that could be infringing. So some of you might have seen from news articles, if You use Claude or DALL-E or any of the other tools out there and say, I would like a picture of a cartoon Italian plumber. And then the output looks an awful lot like Mario, or maybe exactly like Mario. That's almost certainly going to be an infringement of the copyright that Nintendo or whoever else owns. Question then is who should be held liable for that? Maybe you intended that you wanted Mario to come out. Maybe you didn't know and you just wanted another picture of a cartoon Italian plumber. And whether Anthropic or OpenAI, whoever might be the company behind the AI system, they likely didn't want that infringement to happen because they don't want to be on the hook for statutory damages under the Copyright Act that could be up to $150,000 per infringement. So all these things have changed the paradigm of how we think about causation and willfulness and volition in copyright. And this kind of has been happening over history, where for most of the history of copyright, we kind of knew who the infringer was and who we would want to hold responsible. So if you kind of took a drawing and copied it by hand, obviously you're the one who is the copier and you should be held liable. Similarly, if you hear someone playing a piece of music and then you decide to perform that in concert, we also know that you're the one who's to be the copier. But as we start to get more complex machines, that changes a little bit. So courts hadn't really talked about copyright in terms of causation too much prior to the 1990s, because it was that former paradigm. In the 1990s, then we start to get the internet and other reproductive technologies like VHS tapes and then ultimately DVRs and remote DVRs and how to think about who should be held liable in those cases. If you're merely setting up a system that could lead to infringement, is that going to be sufficient to hold you liable? Or instead, as courts have ultimately held, do we care about the one who's actually pushing the button and says, I want you to record now? So ultimately, that's the paradigm that kind of came out of that. More complex than the first kind of existing structure prior to the 1990s, but not as complicated as AI, where now we have to think these AI companies could do everything within their powers to prevent infringements from occurring. Infringements will still occur. That is almost certainly true. Computer scientists agree on this. Legal scholars, maybe reluctantly, have to agree on this. Maybe it's not going to happen that much in pure comparison of like the millions to billions of outputs that generative AI will produce, but we will have some infringements. So thinking under that same causation paradigm, who should be held liable now? So what I've kind of been thinking about is we should still think about who's causing it. And we should also think about the role of intent here. So the actual causation seems to be coming from the AI system itself. And that seems a little strange because the AI system is not a person. And we hold non-people liable under US law all the time. But it's still a little bit odd to say the AI system is going to be held liable. But the reason why we might want to do that in the AI context is because copyright is a strict liability tort. So we don't care to hold you liable that you didn't intend an infringement or that you did intend infringement. That doesn't matter. We might care about it when allocating damages, but you're still going to be on the hook. But a paradigm called secondary liability does care about that. So secondary liability is where someone else has infringed, but we're going to hold other parties liable for that first party's infringement as well. And because secondary liability does care, if we hold the AI system to be the direct infringer, we could hold the AI system provider, so the OpenAIs, Anthropics of the world. We could also hold the users, like you and me, liable depending on what our actions are. So if Anthropic, let's say, knows that there's a big problem with Mario's appearing in outputs, it should probably have to do something about that. We want the law to encourage that to prevent those infringements from occurring in the future. But if we're just saying, oh, you did everything you could to avoid the Mario problem, one popped up again, that seems more counterintuitive, that we wouldn't want to encourage the law to hold one liable under those circumstances. Similarly with you or me, if we just put a prompt in and have no intention of getting Mario out, we wouldn't want to hold the users to be liable. But if we're actively trying to use it to get to the system to infringe, that seems different. And maybe the system's saying, no, I can't do that. And some folks might have seen this with various styles on different AI tools. So if you ask it to do something in the style of Warhol, certain AI systems will just say, no, we can't do that. It's not that hard to really get around that, not that I'm encouraging it. But if you are trying to get around it and then ultimately get something that's very similar to a Warhol piece that could be held infringing, you maybe should be liable for that. You had certain actions and were trying to get it to infringe. So that's kind of where I land in that piece of thinking not just about this bigger question of should training an AI system on copyrighted works be infringement or not, which is kind of the big question that courts are grappling with. But this is the next question of, okay, we figure out if is training infringement or not infringement, then for individual outputs, who should be held liable? And that's a question courts will ultimately have to grapple with, but I think we're a few years out from that. We're still a few years out from getting a definitive answer on the training question, let alone the output question.
Are there any sort of precedent cases or current cases that give you and other legal scholars sort of leaning or orientation or signal as to, hey, like the world is sort of thinking this way, or the judges or the courts are thinking this way, or there are a lot of gaps in even understanding the multi-layer questions and considerations that you have just laid out?
So many questions. So taking the training issue, right? So that's where the focus of the courts is right now. There are over 40 cases pending with that exact question around the country. And we have actually just gotten to decisions, early decisions, but decisions on whether the training should be considered what we call fair use or not. So fair use is the most prominent exception to infringement under copyright law. And fair use is for things that are societally beneficial. So for example, criticism, education purposes, news reporting. But it's a really murky concept because it's not just saying like A is okay, B is not. Instead, it's saying we look at these four non-holistic factors and you have to determine on a case by case and use by use cases whether something is going to be a fair use or not. So that's helpful because it allows the law to respond to new technologies. It's problematic because it's a little hard to predict where it might go. So scholars and litigators have been thinking about kind of the cases that are going to be the most important here. And a lot are these kind of what we've termed functionally transformative cases. So cases that are using copyrighted materials, not just for the underlying expressive content, but using them using a large number of these copyrighted works together to create something that's different and has different capabilities. So kind of the quintessential cases are ones involving search engines. So search engines have had to copy a lot of content, particularly with images. So if you think about searching for images on Google, there you get all the little thumbnails, right? And you can see whatever the results are. Those do result in copies, but they're not infringing because they're fair uses. That search function is allowing us to acquire different types of information. We're not really using the images in the same sort of way. If we actually want that image, we're going to click through to it or go to the website. And maybe the most important fair use case related to this involved Google Books. So there was a very major Google Books decision here in the Second Circuit in New York City, and is copying millions of books and putting them up online for one to search through for snippets and to see whether the content might be relevant. Is that a fair use or not? And the court held, yes, this is a transformative fair use. And it doesn't have any sort of real competition problems with the copyrighted works underlying it because you're not going to just use a few random snippets from a book in most cases as a substitute for that entire book. Um, and to the extent that you're not like maybe just for a research purpose, and it might even build the market. If I see a few lines of, oh, this book actually seems to be really relevant to my research, maybe I'll want to use my research budget to go out and buy that book. And then that's a sale for the copyright owner and their publisher. So that's kind of those are the main fair use cases. We also at the same time have two older cases from the early 90s involving old style video games and interoperability. So if we take some video game cartridges, We kind of reverse engineer them to figure out how do we actually connect with like the old Sega platforms, then is that going to be a fair use or is it not? And the courts there held that interoperability, trying to figure out how to actually get a new video game to work in the player for the old video game was okay because the courts weren't, or the various video game companies weren't trying to copy the expressive content. They were rather trying to figure out the factual points underlying it. How could this actually be played? In this way, it's not undercutting the market. You can now play two different video games on the same system. So it's actually improving more expression and access to a wider variety of the populace, which theoretically is an underlying goal of copyright law itself. So with all of that background, and that's really just scratching the surface, there are many more cases I could go into. Where do we go from that? So as I mentioned, there are two cases that just came out a matter of weeks ago. So on the 23rd and 25th of June, two decisions out of the Northern District of California, where you teach at Berkeley. And they are very interesting. I was on vacation at the time, so I was kind of kicking myself that I couldn't read them right when they came out. I guess I could have, but didn't want to ruin the vacation. But now having kind of had the opportunity to sit with them, digest them, see what others are thinking about, um, they have some interesting aspects, and it's hard to really say that the decisions are a solid win for either rights owners or for AI companies. So the first decision from Judge Alsup in a case involving Anthropic, there, Judge Alsup said that training a generative AI tool on copyrighted works is a paradigmatic transformative fair use. So this seems like a good win for the AI companies. He goes on to describe how AI tools have a very different purpose. The models incorporate into the systems, allow them to do a variety of things that the initial copyrighted work would not allow. It could be used for things such as language learning, editing, pulling different things together, creating new creative works, a wide variety of things that merely reading a book would not allow. He also does this kind of interesting comparison between human learning and AI learning, where he kind of equates the two in a way that is not quite accurate from a computer science perspective, and suggests that, well, we would never stop a individual like you or I from reading a book and then using some of the content from that book and incorporating it into our own works. Like the mere fact that we might remember what Harry Potter did in book one and put that into an essay or something isn't necessarily something that we would want to block as a copyright perspective. The issue with that is that you and I are not memorizing it in a way that AI is, where it's actually coded into the system potentially, and that it always has the ability to pull from those copies. Recent computer science and law literature has suggested that kind of the copies or the works are in the machine, and that while we don't always see them in the outputs, they potentially could always emerge. And that's a really tricky aspect. The wrinkle with Judge Alsup's decision is that Anthropic, in addition to the training purpose, was also maintaining this extra library of copyrighted works largely acquired through online illegitimate libraries like Z Library and Books3, etc. And merely keeping this kind of library on the side, saying, oh, we might use it for AI training in the future or something else or whatever, that's not going to work under Judge Alsup's reasoning because you could have acquired those books lawfully. You can't just kind of have a library and expect that that's going to be okay. Um, that could be different because in this case, Anthropic both had that library of illegitimate books, and there were also copies, PDFs that were made by scanning physical books that they had purchased. And he does distinguish between the two. So the latter might be okay, and that is what also happened in the Google Books case. The former of just taking Z Library and having it on hand, not so good. But that is a potential wrinkle of what Anthropic does versus what some other AI companies might do. So that's the first case. The second case involves a different judge, Judge Chabria, and this one involves Meta Platforms, so the former Facebook. And in this case, it's also a win for Meta their use is a fair use in this case. But Judge Chabria, and this is quite interesting for a judge, spends almost half the decision just lambasting AI companies and saying this really should not be a fair use, but here it is. And at certain points seems to criticize the plaintiffs and basically saying, plaintiffs, you did a really bad job. You didn't provide any evidence of market harm or really even allege that there was any harm by having these AI systems out there. That's somewhat improper because it's not actually related to the decision at hand. But that does suggest that there might be some concerns for other cases that are better argued before Chabria in the future. So he seems to take tact of this theory of market dilution. So usually under copyright law and fair use, we think about these kind of more limited aspects of competition and market effect. So you can't put out a very similar book to mine because people aren't going to buy my book anymore, although, or they will buy it in a smaller amount because they'll buy your book. That's the type of competition that market effect cares about. Instead, this market dilution theory is basically generative AI is creating works, full stop. Those works could compete in the marketplace with the original works on which they were trained, ignoring how similar those works are to each other or anything like that. And this kind of grandiose market dilution theory is very new and doesn't really exist in prior copyright law. Where it might come from is the Copyright Office endorsed a very similar theory in this pre-publication report that it put out in early May. That report itself is a series of kind of more controversy and drama than copyright has maybe ever had, where the report was released on a Friday. It's listed as a pre-publication report. Who knows what that means? We have not seen it in any of the prior AI reports that came out of the Copyright Office. Within 24 hours, Shira Perlmutter, who was the Registrar of Copyrights, was presumably fired from by President Trump. That's being litigated in the courts now, whether that was actually appropriate or not. But all to say, very questionable of does this report mean anything? Should folks be following it? But it also brought out this kind of new market dilution theory, which was rather criticized by many scholars at the time. Fast forward a month and a half, now Judge Chabria writes a very similar type of opinion, really focusing on market dilution. And he recognizes that the purpose is likely transformative. It is a different purpose. It can do all these various things, much like Judge Alsop said. But he said it's not enough because this market effect could be really bad because it dilutes the market. So we have this kind of nebulous market dilution theory that in future cases, as Judge Chabria mentions repeatedly, should lead it to not being a fair use. Here, because the plaintiffs just never alleged that there actually was any harm to the market in that type of way, he has to rule for Meta. So we have these two decisions. What's going to happen after this? So I mentioned that we have 40 plus cases. So these are two of
Yeah.
them. We're going to have a lot more decisions, and not just from the Northern District of California, although that's where the bulk of the litigation is. But we have some pending here in New York, some in Delaware, other places as well. So that will kind of continue to percolate. Um, Likely these cases will be appealed. So it's probably not the last that we've heard of Meta and Anthropic or the plaintiffs in those cases. They'll likely go up to the Ninth Circuit, which is the Court of Appeals that lies above the Northern District of California. The big question is what the Ninth Circuit will say. Kind of district courts can say whatever they want, but I don't think there's doubt in anyone's mind that one of these cases will ultimately go up to the Ninth Circuit and have some sort of decision. If the Ninth Circuit says something, then the question is, will any of the cases here in New York go up to the sister Court of Appeals, the Second Circuit? And then will the Second Circuit and the Ninth Circuit agree? If they don't agree, that sets up a potential conflict, which the Supreme Court would almost certainly have to take up. So while we now have two early decisions, which are a mixed bag, more to come. So we'll have to keep talking about where
Yeah,
this is
we'll
going to
have to
go for the next few
have a
years.
part two of this conversation, part three. So it's very interesting how you gave us a very, in my view, sort of a 360 with sort of the state of affairs, and from a legal scholar's perspective, how to interpret the reasoning and the writing from the current cases. There are a lot of people using generative AI, both in the industries, and individuals are using them, students are using, like everybody's using them. And there's no stopping of new large language models coming out. The agents are powered by these large language models. So there is sort of a perpetuating effect, like things are getting bigger and bigger, and there is more and more adoption. Imagine a world where most of the content are also machine generated by
Mhm.
these large language model. Like how should we even think about that?
It gets really interesting. So there are some legal scholars starting to think about the synthetic data, and
Right.
particularly from the privacy perspective. And the interesting thing is, even though it's synthetic, which could seem valuable both from a privacy perspective and from a copyright perspective, because it's theoretically different, right? It doesn't have the information or shouldn't have the information about you or I in it. It shouldn't have kind of the creative works because it's based on later versions of the works. Those things could still incorporate the initial sensitive data or copyrighted content. And we can't kind of exclude those. Stakes could always come back up and could inadvertently reveal certain information about ourselves. There's kind of also the question, which some computer scientists have posed, of is synthetic data decent enough quality for kind of the second generation, third generation AI models, which I'll leave that to the computer scientists to figure out. Um, but the point is, it's not a panacea for the law either. That maybe it's slightly beneficial and maybe can lower the chance of a copyright infringement or lower the chance of privacy violations, but these things could still come through. And we should still be cautious of those. And also think about kind of what the importance is of being human. Of if we care about these AI systems for certain tasks, at least, maybe not everything. If we want to get out of a speeding ticket, maybe we don't care about the human approach, but we just care about kind of the most right approach or filing our taxes, et cetera. But if we're trying to think about creativity, there we might be losing something by trying to use the second generation synthetic data compared to actually using human data. And we're already seeing that a bit with kind of the use cases for AI tools. So, for example, it's, I think, quite helpful to use generative AI for revising a paragraph. Of can you make my writing a little bit more concise? I use it a lot to think about titles of articles because I am very bad at thinking of titles of articles. So it's kind of helpful just to like bounce ideas off of it. Oh, can you add this word? Can you make it in the style of this law review or this journal? Um, but if I just ask it, hey, can you write me a paper on AI outputs and who should be held liable for copyright infringement, it's not going to do anywhere near as good of a job, I think, because it's not able to kind of have that same degree of reasoning and kind of understanding the human aspects and potential counter arguments. I think it will certainly improve, but that human element is still quite hard to grasp. I think that's one thing that artists should consider as well of what is kind of the value proposition of artists still doing art when AI can now do things in a very different way? Well, it kind of depends on what we're trying to use it for. If I'm wanting to put art up on my wall, I'm probably looking for something that's not just an AI generated piece. And that's even coming from someone who studies AI and copyright. I still prefer the human work. But if I'm just wanting a stock image to go on a PowerPoint slide for class, there maybe I don't care so much. And whatever Anthropic or DALL-E could spit out, I'm good with that.
Yeah.
So thinking about those use cases can be helpful. I think we can take certain lessons from that and think about them in other fields as well, beyond just the arts.
Yeah, I think that's a really good clarification, is also thinking about what's the purpose of using generated content. And the example you lay out, I think elucidates that. So with your students, like what are the questions that, for the future lawyers and legal scholars, what are the questions that you're asking them to think about and consider? And are they allowed to use these AI assisted tools?
Yeah, so I think a big aspect that will come up in copyright as I'm teaching it this coming semester is not just what the correct legal answer is, but also is it kind of the morally correct or ethically correct outcome. So two aspects that folks have been starting to think about in kind of the training of let's say that training is a fair use, which a lot of scholars think it probably is. But let's say courts have decided it is a fair use, this is happening. Then other scholars, particularly in Europe, have been thinking about remuneration. So should we be paying underlying authors something for the fact that AI can really disrupt their work and it is being used? And another aspect is opting out. A lot of this work, or a lot of the underlying training data has been scraped from the internet, largely without permission of copyright owners. So should we think about instead of some sort of opt-out system going forward, where if you don't want your information to be there, then you have to opt out. Some have also proposed an opt-in system. Europe seems to favor the opt-out systems a bit more because it creates less friction in the training and kind of just the procedures more broadly. So we'll have to see. I think those are both really valid considerations. I'm starting to work on a very early piece, thinking about kind of remuneration and licensing of copyrighted data and who it actually benefits. Of so far, there have been some agreements between large IP owners and intermediaries and the AI companies for using the data in the training. And these have been largely with the largest IP owners in the world. Like thinking of like the New York Times, deal with Reddit. Um, some of the various record labels are starting to have discussions, Condé Nast. And if we're really just benefiting kind of the large IP owners or these intermediaries, they're the ones who are going to be making money on this. And they're the ones who are going to be largely dictating the perspectives that we see in AI outputs in the future. And if do we really want a world where AI is controlling most of our basic tasks and it's now being governed by effectively the voices of Condé Nast and the New York Times and them alone, compared to voices of you or I who don't have that same degree of market power. And this really is being controlled by just the sheer amount of data that these AI companies need. If they're trying to go around to each individual and ask, hey, can you give us some of your data, et cetera, especially for copyrighted works, that's going to take a lot of effort. Instead, they can just go to the New York Times, which can probably give them millions of articles written over the last 100+ years. It's probably already cleaned up, better formatted, all of that. That's a great deal for them. And I don't blame them from a financial perspective why they would want to do that. But the issue is it then leaves out other perspectives. And if we think about AI kind of becoming this repository of our collective knowledge, we start to leave out other perspectives that then will be forgotten much more quickly than it maybe would have in the past when we had a variety of different sources upon which we might rely. But already we're seeing if you go to Google, there's the AI summary at the top of your page. And as much as I try to avoid it every single time, sometimes you're just drawn in. You're like, oh, this seems reasonable. So all questions that we should kind of consider as we think about those potential limits of who's being left out of the picture in this new AI world and who's potentially being brought in.
I think that's a great way to end it here, Michael. I really think we're going to do a part two and part three and just explore some of the other areas, as you mentioned, not just law, but sort of thinking about the ethics, the moral obligations. And, there are a lot of discussion also about the impact of AI on the market, on jobs. Um, and there have been some, really famous people who have worked at Google and others having very strong view about this. And I think will be interesting to have those discussions as well. So thank you so much, Michael, and we will be following your research.
Thanks so much, Joyce. Good as always to talk to you about these breaking topics, and we'll see, yes, at least three more parts, if not many more, with all
Well,
of
it's
these
two out of 40
questions.
cases, so there's a lot more to digest.